Hello and welcome to Bite Size Legal, where we tackle legal issues one bite at a time. My name is Drew Jenkins and I'm an attorney licensed in both Alabama and Georgia. And today we're going to be talking about powers of attorney as they relate to real estate in particular. While most of you probably know what a POA is, we're just going to do a brief review. So what is the power of an attorney? When a lawyer walks into court, anything that they say or do is considered to be said or done by the client. So in effect, the attorney is legally someone else. So to grant another person the power of an attorney, if you do so, is to cause that other person, for those specific purposes in the power of attorney document, to become you. Typically, they exist in estate planning or end-of-life decision-making. In order to, if something occurs to you where you are rendered unable to make decisions or unavailable, then someone is able to make those decisions for you, particularly as it relates to finances. Of course, bills are still going to come in. There are going to be contracts that need to be negotiated and signed. And if you're unavailable, using the court process can take a while and is just simply unnecessary when you have a power of attorney. Powers of attorney are more commonly seen in the real estate context. Let's say that you have it's typically your seller, although sometimes your buyer is unavailable, but they're willing to sign and enter into a contract or to sell their property, but they're simply not going to be there to sign the closing documents. So what we're going to do is we're going to give someone else the power to sign on their behalf. We're going to cause them to become not an attorney at law, but an attorney in fact for a limited or specific purpose. We don't generally use the term attorney in fact anymore. You may have seen for years, and you will still see, it will be signed by the owner or the principal's name, by the agent's name, comma, his or her attorney in fact. To make life simple, the person who should be signing but is unavailable, we're going to call them the principal. And the person who is actually signing with authority, we're going to call them the agent. So in any power of attorney, you have a principal and you have an agent, and there is a document or a contract that will specify exactly what powers the agent has and what restrictions on those powers. So in the real estate context, what we like to see what's known as a limited power of attorney, one that is limited to a specific transaction and will last for a specific period of time. So for you realtors out there helping people through this, if they're not going to be available, look, here's what we need. We need a limited power of attorney that will grant someone the authority to sign the closing documents, or I do not recommend that they have the power to sign a contract. We have e-signing these days, so unless they're somewhere really without internet, just go ahead and ship the contract through whatever you use, .loop, right signature, HelloSign, whatever it may be, and have that actually signed by the principal where possible. There are certain documents that have to be notarized, and those are the ones that we really are going to be looking for, and the documents at the closing table for the agent or the attorney in fact to sign those. So what do we need in our limited power of attorney? We need it to be limited by the transaction or by the property. Give as much information as you can give in it, right? Seller, buyer, contract, dated, for, street address, see attached Exhibit A for the legal description. And we want to make sure that if something happens to our principal, that power of attorney doesn't unexpectedly terminate or dissolve. Right, so an important context for powers of attorney are that they need to be capable of revocation. Alabama changed the law a few years ago on this. Now powers of attorney are generally considered durable unless otherwise. So just make sure that you have in there, just so it's crystal clear, that look, if something happens to me, I'm in an accident and I'm unable to revoke this consent, it's still going to continue. And here's who the agent is. Here's how I identify him. And there's typically another page on the end where the agent will sign and say, yes, I am aware of this. I'm aware of the powers I've been given. I'm aware of the restrictions that I've been given. And I agree to serve, right? And that is your agent certification. Now, in real estate, there is an additional hurdle that exists. And that is due to title insurance, and it is due to trying to keep the record system clean. So when most people think of title, yeah, it's those guys over there, it's that company that we don't know much about or deal with. However, I do know that they tend to screw up deals. And the reason is because in the record system, we need to make sure that A sells to B, B sells to C, C sells to D. Someone else claiming that their D sold to E. Well, wait a minute. All right, I see a signature into this person, but I do not see a signature out of this person. I see someone else who's claiming to have the power, but in order to feel comfortable, right, insurance companies hate paying claims. So in order for them to feel comfortable with this transaction, we need a document filed in with the deeds that says, signed by the principal, right, the signature that we were expecting to see, that says, yes, I know, however, I'm not available. I've granted them the power to sell this specific property. Thank you very much, right? And the hurdle is that to file deeds and security deeds in the record systems has an additional signing requirement above a basic power of attorney, right? I can sign a document that says I want so-and-so to operate on my behalf. I can have it notarized, I can have it witnessed, depending on the state. I may just be able to sign it and turn it over and we're good to go. But if we want it in the record system, we have to make sure that it meets the same signing requirements as deeds. So in Georgia in particular, we need to make sure that this limited power of attorney contains both an unofficial witness and a notary signature, but it's no longer an acknowledgement. It needs to be the full attestation, certified that this person signed it in front of me. It's no longer, hey, I walked in, I promise you I signed it here. Will you acknowledge that I have certified that I have signed it? We can't do that anymore. It actually needs to be signed in front of the notary. So that's just an additional wrinkle for real estate that you need to be aware of. It is absolutely a requirement. Otherwise, the title insurance companies are not going to want to accept it because, again, it's going to create a question of title. What gave this purported agent the ability to sign on their behalf? In the Asian community, a lot of people will travel back to their home country for a period of time. It may be for a few months, it may be for a couple of years, depending on what's going on, but they still need to be able to sell the property. Do we have to ship documents overseas? And the answer is no, we don't. We can have it notarized. And the next question is, well, can they just go see that local country's notary? And the answer is maybe. There's a federal law that says certain countries, basically, we trust their systems enough that if they notarize it, we're okay with it. And that's that. However, a lot of countries are not on that list. So in that case, what your principal is going to have to do, what your buyer or seller, and it's almost always the seller, they're going to have to go to the closest U.S. consulate and have that document, that limited power of attorney, executed in front of a consular officer. And don't forget, we still have to meet our state requirements. So for the state of Georgia, there must also be not only that consular officer's notarization, there must also be an unofficial witness. Then the original of that document must be shipped back to the United States in order to be recorded, because we, of course, need originals for our files. And that sort of gives you an idea and an overview of powers of attorney for real estate. So just to recap, you want it to be limited. You want to specify the property or the transaction. You want to ensure that it is durable, and you want to put a time limit on it, right? If you already have a contract, go ahead and figure out how long, add a couple of weeks just in case there's an unexpected delay, and it will automatically expire after that time. If you don't have a contract yet, you can make it 90 or 180 days, but we also don't want them to be open-ended because that can raise questions of authority. Not legally. Legally, it's fine, but remember, most transactions are going to involve a lender. They're going to involve title insurance, and insurance companies, again, hate paying claims. So they're going to like to see certain reasonable restrictions that aren't going to raise caution flags later on. I hope you found this. Enjoyable, and I hope you found it informative. If you would like to see me talk on a specific topic, I recommend that you email me. I can be reached at drew@jenkinstitle.com. That's drew@jenkinstitle.com. Send me any questions that you may have, and we'll see it come up. Until then, see you next time. Thank you.